Welcome. My name is Greg Peacock, and this is Devorah Pasternak, and we are domestic violence prosecutors with the Summit County Prosecutor's Office in Akron, Ohio. And we specialize in prosecuting cases of domestic violence involving intimate partners.
Our goal today is to share with you some best practices about how to successfully prosecute domestic violence cases. The three components to a successful prosecution include gathering critical evidence at the scene, meeting with the victim, and then working your case toward a plea or a successful trial. You're a veteran prosecutor with over 25 years of experience. Based on modern technology and your years of experience, what do you expect to look for out of a domestic violence crime scene investigation?
Well, I think the most important thing is documenting the physical evidence. The police are able to do that more with their body-worn cameras, and so we get video evidence of the victims immediately after the incident, where it can document their injuries, their state of mind, what the house looks like, things like that. But we also have some other modern technology which the police do need to gather at the scene, such as video cameras for phones. People record so much on their cell phones, but also ring camera footage. Everyone has a ring camera, it seems. And we do have an example here I want to show you of some good evidence of a guy after a domestic incident trying to go after his spouse and trying to get into another person's house, and we had that on camera. And I think it's a good example of how a domestic incident can continue even after the physical assault, and the type of evidence the police can gather which will be helpful to us.
Do not go in my fucking house! Bastard! Do not go in my house! I did not give you permission to go in! Your arm is cut!
I'm here to see my wife.
Yeah, you are not coming to my house.
There's also the text messages, but I think more the videos we get off the cell phones. And the text messages are good in a protection or a violation cases. But it's important that you advise your law enforcement to gather the evidence at that time, at the scene, not rely on the victim or witness providing that later. Because as we know, so many witnesses or victims may change their story, recant, things like that, and that evidence may disappear, or they're not going to be willing to send it to us a week later, 2 weeks later. So the police really do need to gather that at the scene.
The ring camera evidence was such a good example in the video that we just saw. In addition to the evidence recovered from the scene that you would expect from law enforcement and the police on the ground, what other types of evidence should a prosecutor be looking for that surround the circumstances of the domestic violence incident?
Well, you would look for the medical evidence. If there's any medical evidence, did the EMS come out? Did they write up a report? Did they document injuries? But again, so many victims, they don't want to go to the hospital. They don't want to leave their kids at home. They don't want to sit in the ER for 4, 5, 6 hours, or they don't want to. They worry about the cost of being transported in a squad. So I find lately that we don't get quite as much from the EMS reports, but it's a good place to start. And your officers should document whether EMS came out, and then you can usually order that report, see what you got, and go from there. Your medical records, if the victim is admitted to that, to the hospital, get that release from her as soon as you can, and so you don't have to get a court order for that, and see what documentation they have. And also the police can go to the hospital and also document the injuries there.
Good point, good point. And as well as what you're talking about with Greg, is that some of those interactions about the medical treatment or the injuries are then going to be on the officer's body camera footage.
Right. And then the old-fashioned method of gathering evidence is a 911 call. That's often still our best evidence, and you should have a recording of that, and your officers aren't going to have that for you, so you need to get that yourself. And there's a good retention policy on those, and so you have a few months, a year to get that. But again, it's great evidence. It gets that excited utterances, those initial statements from the victim or the witnesses calling. Sometimes it's the neighbors calling, and they're often reluctant to leave their names, but they may be describing an ongoing emergency. What's not excited utterance? The present sense impression. They're watching a domestic incident. Mm-hmm. She's in the yard. He's beating her up. She's on the ground. All that's good evidence you can gather from the 911 call. And keep in mind, there's often multiple 911 calls that come in. So get all of those.
Hello, can you please hurry up and send somebody over here? My neighbor is outside. She is pregnant. She is like 5-6 months pregnant. Her boyfriend is on top of her. He got a cigarette in his mouth. I think he drunk. He won't get off of her. I heard her yelling. So I opened up the door, and she just told me, like, please call the police and send him over here immediately because he won't get off of me. And he hit her a couple times and got her on the ground. He won't get up.
Great example, Greg. And in this 911 call, as we heard, the witness describes the ongoing urgency and the seriousness of the situation. So what's next, Greg?
Well, we've done a 911 call, but and medical records and your cell phone videos and your Ring camera footage, but then you go to your body-worn camera footage from the officers, and now we see almost all jurisdictions will wear body-worn cameras, and even today, as I'm presenting cases in grand jury, we show body-worn camera footage. It's the most compelling evidence when the officers are first walking up to the door and the victim's coming out of the house and telling what just happened. It's wonderful evidence, and we found to be very effective. And if you can get that to your defense attorneys immediately, they can begin working with their clients and explaining, hey, even if your girlfriend, wife is going to change her story or change her version of events or recant, the prosecutors are going to use this video, and this is what the jury is going to see, and it's a way for them again to start working towards a resolution on the case as well.
So once a prosecutor gathers all the evidence that's out there about a case, the medical records, the 911 calls, reports, photos, video-based evidence, what's the next step for the prosecutor?
You need to make the contact with the victim, and you want to also impress upon your officers to get that phone information, accurate phone number, and also a backup phone number. And so if you are able to get a hold of your victim, then you need to bring them in for a meeting. Having them doing interviews over the phone is really not a good practice in my experience. They'll ask you to drop charges over the phone, and our standard reply is we don't drop charges over the phone. You need to come in and talk with us, and we'll have and always have an advocate there with you in the room. I think it's always a good idea not to meet with the domestic violence victim alone. So because you just don't know how this is going to go, and oftentimes a victim who's in a dangerous, vulnerable situation will say, the prosecutor lied to me, or the advocate lied to me. I didn't, or and you don't want to be in that situation. So I think it's always good to have someone else there and to take contemporaneous notes of your interview, not recording it, but take contemporaneous notes, either just writing it on a legal pad or typing them into your computer as you go along, and tell the victim, hey, I am going to be taking notes. I'm putting them into our case management system. If you just see me looking away and typing that's what I'm doing.
So, Greg, since domestic violence victims present different challenges compared to victims in other types of cases, how might you prepare differently for meeting with that victim of domestic violence?
Well, you have to do your homework prior to the meeting. You don't know in what position she will be or what tack she may take when she comes in. She may have, there's just too many variables. So the only thing you can do is prepare and be ready for whatever comes along, and you will always be surprised. Doesn't matter how prepared you are. So I think you've read your reports, you've watched the body-worn camera, you've listened to the 911 call, and also the jail calls, and we'll play one here shortly where, again, you don't have to confront her with that, but at least you'll know that there's something going on between her and the defendant prior to your meeting. And that gives you, again, something you can know what to expect and how to prepare for the meeting.
I didn't call anyone, though, because I didn't talk to you, so I wasn't sure what you wanted me to do.
All right, well, super simple and easy. If she does not go to the hearing on Monday, which I got a hearing on Monday, and she's going to be able to go, but if she don't go, they'll drop the restraining order and possibly drop the charges. But if she does go, she can go drop all the charges. She can be like, hey, I want to drop the charges. I need my husband, the kids need their father, his family needs them, job needs them, I just going through the motion of stuff right now. Being pregnant, blah, 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 you know? So even though, you know, it might not necessarily be true, but...
You know, I don't think it's a good idea to confront them with jail calls or things like that. You know, and one thing, you have to gauge what's her safety, how does it affect her safety, how does it affect the case. You know, if they're having a continuing dialogue in those jail calls, you may want to just let that dialogue keep going for a few weeks. You know, maybe you'll get some admissions from him if you haven't already. And then you also have a sense, if you're leading up to trial, you know, she could be saying to him, I'm not going to show up, or he's telling her, don't show up. There probably won't be overt threats. It's much more subtle than that. They usually know their jail calls are being recorded. And so it may be a little more subtle about, you know, whether or not to show up for court.
So the jail calls can also provide that context for how to approach that meeting, what you might expect.
Exactly.
But also to react appropriately when the victim's there, because you're not going to be caught off guard.
Right, exactly.
So Greg, let's say you've done all the things you're suggesting, but due to the unique dynamics of a domestic violence case, the victim recants or disappears and won't cooperate. What then?
Well, I think that's tough for prosecutors. You don't always know why she is. You want to find some logical reason, but there may not be a logical reason. It's usually an emotional reason why she is, you know, backing out of the process at this point. And I think, you know, our nature is to want to help, and we want what's best for her. And she may be telling you, what's best for me is we don't prosecute this case. I feel safer if we don't do this. I don't want to be around him, or, you know, I need him for whatever reason. And when would you say you should meet with the victim?
I'd suggest meeting with the victim as early as possible. We've seen, and I'm sure you've seen as well, that victims can begin to recant their statements as early as prior to grand jury.
Oh.
So meeting with them and developing that rapport early on and maintaining a relationship with them, even if you disagree on your positions on the case, is critical.
Yeah.
So, Greg, let's say you end up in trial. What has been your experience with the response of juries to cases in which the victim is not part of the case in chief or doesn't testify?
Well, you know, it's actually counterintuitive. We find often that juries today are fairly sophisticated about the dynamics of domestic violence, and that they seem to get it. And actually, if your victim doesn't appear, and then you have all this other evidence, they're going to maybe figure out that on their own that she's scared or other things are going on, and they're not usually going to hold that against the state. And that's what our office has done for years, 20 years now, is prosecute cases with uncooperative victims, and we've had a high success rate with that. Actually, we find that if the victim does come in, she actually hurts the defendant by not coming in. It's
Mm-hmm.
actually better for him if she comes in and she's in front of the jury and then is doing her recantation. It's a little harder for the jury to discount her when they've actually had her on the witness stand under oath. It's sometimes if she's just this woman out there somewhere, it's easier for them to, you know, to side with her. It's domestic violence is emotional, it's dynamic, and the way you're feeling on it is often the way the jurors are as well.
Good point.
Yeah.
Greg, thank you so much for sharing your experience with us on prosecuting domestic violence and sharing some of your best practices from Summit County Prosecutor's Office. Greg and I wish you success in your future prosecution.